This is Kevin Myles from the Wichita branch, NAACP, and I'd like to talk a little bit today about the issue of employment discrimination. A few years ago, actually 2 years ago, the Wichita branch NAACP put together some legislation that would deal with the issue of wrongful terminations inside of the state of Kansas. And the reason why we put forward this legislation to deal with wrongful terminations is because what we had found over the course of a few years dealing with these types of complaints was that there was very often very little, if any, remedy that was available to someone who felt that they had been wrongfully terminated. This is not by accident. You see, the state of Kansas is what you call an at-will state. It is a purely at-will state. And most people, when they talk about the subject of employment law, will mistakenly refer to it as a right-to-work state. But right-to-work actually applies to unions. It is not a measure that deals specifically with the issue of wrongful terminations. With regard to terminations, we are an at-will state. And what that typically means, the doctrine of at-will, is that if an employee can quit a job at will, then the employer should have the right to terminate an employee at will. And the way that this manifests itself is sometimes troubling. Oftentimes it can be a very good business tool. And because of that, employers typically defend at-will status, and some believe that it is a necessary component in creating a healthy business environment. When you start to talk about tinkering with or removing at will as the doctrine by which hiring and firings are governed, typically what you hear from businesses is that, you know, if you were to remove that, then it makes it difficult for them to maintain a qualified workforce or a healthy and strong workforce, because they lose the ability to terminate those employees who are not performing at the rate that they feel is necessary. We don't believe that. Not because, you know, we are superior economists, but simply because, you know, as everyday people, as working people, and as a watchdog organization who deals with these types of issues all the time, we're not arguing, and it was never our intent to argue the fact that, you know, companies should be straddled with maintaining underperforming employees. Rather, we would argue that employees who are performing their job, who are working to satisfaction, should have some basic rights. You know, to say that an employer can terminate an employee at will, that's not necessarily problematic unless you have an employer who has other than noble motives. And there's no safeguard for that in a system that is purely at will. And what we're looking for are some safeguards. Namely, we believe that any company should be able to provide someone who is terminated from a position with a written explanation as to why they were terminated. That seems very simple, very self-explanatory. However, in an at-will type state, as we are here in Kansas, you have no basic right to a written notification of the reason that you were terminated. What this does is it creates a situation wherein if you feel that you were terminated wrongly and you choose to pursue that, pursue your legal remedies to determine whether or not you were terminated wrongly, all you have to go on is the reason why you may have been told verbally, if you were told a reason at all. As your case proceeds, the company is then able to revise their reasoning for having terminated you until they can find reasoning that would suitably justify it. And even in saying that, I need to back up just a little bit and explain how a wrongful termination can take place in an at-will state. Because we are an at-will state, like I said, the companies do have the right to terminate an employee at will unless it can be considered a wrongful termination if you were given a reason for your termination. That reason can be proven to be materially false, and the person who effected the termination was also involved in the creation of the story which proved to be materially false. that is critical. That the person who does the termination has to be involved in the creation of the story that was given to you that was materially false. And it has been ruled by courts within the 10th Circuit that, you know, if someone is terminated from a position on the basis of information that isn't true, but the person who effected the termination was not materially involved in the creation of the lie, then the termination can stand because it was not an intent to discriminate. It may have been a wrong action, but they are within their rights to terminate on the basis of that wrong action, as long as the person who effected the termination was not involved in the lie. So what that scenario creates is a window of opportunity for malfeasance. In that, if you were terminated and your only hope of proving a wrongful termination is to show that the reason that you were terminated is materially false, but I am under no burden or obligation to provide you with that reasoning in writing, and I have the ability to revise that reasoning throughout the court proceedings until such time as I do provide it in writing, then obviously I have the ability to cover my tracks, so to speak. So we want to make it so that someone who is terminated from a position has a right to receive that reasoning in writing. And if there is no malfeasance, and if that person is not performing, then certainly this change would be of no effect to a company or corporation, that hiring and firing practices were all above board. Secondly, in addition to making sure that a person has the right to receive the reasoning for their termination in writing, we would also like to see some language that would either mandate or encourage companies to use a progressive disciplinary policy. Now, this is something that is commonplace in most companies and corporations of any size. And this basically what it states is that if and there are differing degrees, but you know the essence of it is if an employee is underperforming, that employee should be counseled. They should be told what they are doing that is not up to par. They should be given an opportunity to correct those behaviors, and if they do not correct those behaviors, then a termination can be effected. But there should be steps involved. We would like to either mandate or encourage that a policy similar to that be put in place throughout the state of Kansas. These are the things that we, as the Wichita branch NAACP, have been pushing on the subject of employment law and employment discrimination within the state of Kansas. And I will certainly keep you all abreast, both by video and also on our blog, which is basically just Wichita NAACP blog.com. But I'll keep you guys abreast as we move forward and move towards this next legislative session in hopes of getting something done with the at-will statutes. Our ultimate goal, what would be optimal for us, would be to see the state adopt something more along the lines of a just cause doctrine, as they have out in California and Montana, which says that if someone is terminated, then the onus is on the company to show that they were terminated for a just cause, broadly defined, so that no company should be saddled with underperforming employees. But in the interim, short of attaining to a just cause doctrine, we would be satisfied with language that would provide workers with some basic rights, those being the rights to have the reasons for their termination provided to them in writing, and also that a progressive disciplinary policy be put in place for anyone who is facing possible termination from a position. Again, those are our positions and the things that we are advocating for here within the state of Kansas, and we will certainly keep you all abreast here on this channel or also on our blog.